is now open. All that business for this court, draw near to the attention, and you shall be heard. God save the United States, the great state of Florida, and this honorable court.
Please be seated. I assume Mr. Wheeler has done his normal good job and has explained the operation of the clock, so I won't go into that. I will try to help you watch your time, but I will try not to interrupt. We are going to take a break after the first case because we need to reconfigure the panel, and at that time we'll have coffee in the Commons, and you're welcome to join us. Thank you. Counsel for the appellant.
Good morning. May it please the court. My name is Bill Stafford. I'm here on behalf of the appellant and cross appellee, 14th and Heinberg, LLC. Your Honors, this is a case dealing with a claim for unjust enrichment based on a construction contract with a tenant in a building owned by my client, 14th and Heinberg. And I apologize, I'd like to reserve 7 minutes. I should have mentioned that earlier. In 2000, the tenant, Montgomery Wards, entered into a construction agreement with the appellee, Tahar and Cronley. And at the conclusion of that construction contract in late 2000, after Tahar and Cronley had been paid 85.6% of the contract price, Montgomery Ward declared bankruptcy, leaving a balance of approximately $183,000 or 14.3% of the base contract price.
Counsel, I think we're familiar with the facts. And your first issue deals with an exhaustion argument.
That's correct, Your Honor.
You're relying on the Commerce case, the in-bank case out of the 4th DCA. And I'm not sure I follow your reading of that case. As I read the case, it doesn't support a requirement of exhaustion because in fact seems to recede from that requirement that was in a prior case, the Maloney case out of that court. So explain. I'm not following your argument. Maybe I'm not reading it correctly.
Well, thank you, Your Honor. I understand your point. My argument with respect to the Commerce case is the requirements in the Commerce case are that where the enrichment is that says that unjust enrichment is limited to the cases where the enrichment is truly unjust, and the citation to Maloney is that when the court is discussing the unjust nature of the enrichment, that's where the requirements of no payment to the contractor and that there be exhaustion of remedies. That's the citation of the Maloney case. As I read,
but clearly Commerce recedes from Maloney with respect to that particular issue.
Your Honor,
I read it.
Your Honor, with respect, Your Honor, my point with respect to with Maloney and the rescission from Maloney was with the requirement that if the contractor have a lien or the subcontractor have a lien, that the court said that they understood Maloney to possibly require a third element, that the contractor fail to follow his legal remedies, including the lien.
Right.
That was the language.
They rescinded on that point, and I understand your reading there. They didn't rescind from Maloney regarding the payment or the requirement of exhaustion of other remedies, the pocket of first resort that your brief refers to. So is it your argument here that the appellee was paid? Because this 85% number you cite for the payment to the general contractor.
Yes, sir.
That doesn't affect the trial court's finding, does it, on damages?
No, Your Honor. What my point with reciting that is that was more in line with the cross-appellant's argument with
Right.
respect to, with respect to entitlement to $1.6 million.
The increased value in the property, but regarding the $183,000 losses plus the prejudgment interest, which I know you contest,
Yes, sir.
those points you just raised don't go to that damage figure, do they?
With respect to the, no, Your Honor, with respect to the exhaustion of remedies, my point there was that the general contractor and the appellee in this case had remedies, had secured remedies in the bankruptcy court, and failed to pursue those.
But isn't the language in Commerce that Judge Van Norwick mentioned, isn't that language that said we recede from any kind of requirement of a perfection of a lien? Isn't that analogous and defeating to your argument that, okay, well, here, appellee had to get a secured lien rather than just the unsecured bankruptcy interest?
I understand the...
We don't have to follow Commerce on that point if you'd like to argue that we should diverge from them, but...
I understand your point, Your Honor. The point I was making there was that the rescission from Maloney in the Commerce case was limited to just those lien issues, and that to the extent that there's an equity component in the determination of whether the enrichment is unjust, the court needs to take into consideration all of the factors, including the fact that the general contractor filed a lien, filed a claim for compensation from the bankruptcy court only as a secured creditor. The lien itself was perfected when the lien was recorded, and that failed to follow up on that, on the secured claim. Our point was that was a failure to exhaust remedies.
But I understand your argument to the extent that you're saying the equity element of this cause of action might take into consideration the fact that not all actions were taken, but I thought you are arguing exhaustion as really a bar. It's a requirement, condition precedent to a cause of action for quasi-contract or unjust enrichment.
That is correct, Your Honor, and that was one of the elements that the court stated in Maloney that was not receded from in the Commerce case, is that exhaustion of remedies argument is still in place.
Well, Counsel, in Commerce
Yes, sir.
partnership, didn't it involve a claim by the subcontractor against the general contractor, whereas here we're talking about a claim by the general contractor against the owner of the premises?
That is correct, Your Honor, but I believe that the principles that there is no privity of contract between the party making the claim and the owner of the property, I believe those principles set forth in Commerce and Maloney would still apply.
Counsel, in your reply brief, you cite a case, Henry M. Butler, Inc. versus Trisec Properties, which seems to be right on point. There, you had a tenant entering into a contract for improving the premises. The lease said that the landlord shall have no responsibility for the payment of such improvement, and yet then there was a lawsuit for unjust enrichment, which at least the second DCA in this case appears to have said is a good cause of action. Why? Now you cited it in your policy argument, but why isn't that case not controlling but persuasive?
Your Honor, I believe I don't have that case right in front of me, but I believe that was a case where the lien itself was not perfected. Here, the contractor took the effort of recording its lien within the time frame, and therefore simply had these lien rights, and it wasn't a matter of sitting on the rights. It was failing to pursue them in a bankruptcy proceeding. I believe there is a qualitative difference there.
I understand. Counsel, you're down to a little under 6 minutes.
Okay. I'll reserve my time.
May it please the Court, my name is Nixon Daniel. I represent Tahar and Cronley, and I'd like to reserve 3 minutes on the cross appeal. Your Honors have gone, I think, directly to the first issue that I'd like to speak to, and that is the exhaustion of remedies issue. The only element of unjust enrichment that has been challenged here is this issue of exhaustion. And the suggestion that the appellant makes is that the exhaustion is a bar to the claim. And I think, as the Court has already pointed out, the Commerce case that they rely on has receded from that. And what happened in this case was Judge Shackelford, the trial judge, balanced the evidence that was presented to her and found and made a finding of fact that there was, in fact, unjust enrichment. She could have taken into account and did take into account evidence that was presented by the appellant at the trial level on this issue of the exhaustion of remedies and what Tahar and Cronley had done in order to perfect and to protect their claim. What is clear in this record is that they, in fact, asserted their lien, and it's also clear that what happened is that 14th and Heinberg knew of that lien. They had to agree to the improvements to the property. They knew the lien had been recorded. And in spite of that fact, knowing that Tahar and Cronley had no notice of the sale or the termination of the lease, entered into a transaction to terminate this lease for $10,000. The evidence at the trial was, the uncontroverted evidence at the trial was, that Tahar and Cronley knew nothing about that. In fact, Mr. Cronley testified that had he known about it, he would have paid several $100,000 for the lease for precisely the reason that we're here today. That is, he had not been paid. The value of this lease was substantial because 14th and Heinberg had taken a $1.30 a foot lease for a warehouse and had turned it into a $10 a foot lease for a call center, totally and exclusively on the basis of the improvements that Tahar and Cronley had made to this property. The trial judge evaluated...
And the record evidence is undisputed on that, or did the market rate also go up during this period of time?
The market rate went up slightly for warehouse space during this period of time, but the record is undisputed that the difference between warehouse space and call center space is dramatic and on the order of 7 or 8-fold. And so while there was some slight adjustment on warehouse space, the issue in this case is the value of a call center, not a warehouse. So I would respectfully urge to the Court that the finding of unjust enrichment has been properly made. The exhaustion of remedies issue was properly considered by Judge Shackelford, and now the issue becomes, what is the proper measure of damage? And in that regard, the issue is, I think, an issue for de novo review by this Court. That is, it's an issue of what is the legally appropriate measure of damage. This is not a case where Judge Shackelford had several different elements of enhanced value that she considered, and she chose, based on evidence that she saw, one of those. She clearly chose the course of compensating Tahar and Cronley for the money they actually had in the construction project.
Plus prejudgment interest.
Plus prejudgment interest, which I'll speak to in just a minute.
Because I don't understand how under Commerce you can make a claim for the increased value of the property under what is essentially a legal cause of action, which they explain so well. That is, a contract and law which evolved from the common law pleading of assumption. So how would you be entitled to a claim for increase in property values, which a contractor never contracts and says, I'll add a bedroom to your house, and when your house doubles in value in the real estate bubble, you owe me that money?
Well, let's look at the Levine case on that issue. In Levine, the lessee, on the basis of an agreement to lease property, improved the property. That deal fell through. And the court in Levine said the proper measure of compensation is the enhancement to the value of the property, not what the dollar amount of the particular improvement might have been. And appellant would make the argument that there's a difference between someone with a possessory interest, a lessee, as opposed to a contract. And I would respectfully disagree that analytically there is no difference, particularly in this situation where the contractor and the owner of the property are the only two left standing, so to speak, when the tenant takes bankruptcy. One of them is going to end up with this lease. One of them is going to end up being enriched by the value of this lease. The question then becomes, where is the unjust enrichment? Does the unjust enrichment lie in an entity, the owner of this property, who knew about the lien, who's taken advantage of the lien, who's collected the rent on the lien, who bought and terminated the lease without notice to Tar and Cronley, or is the equity in favor of the contractor who did the work, who's out the money?
And I appreciate your argument, but if I could ask it this way. My understanding of the contract and law claim under which you prevailed below, right? You prevailed under a contract and law, not a contract in fact.
No, we prevailed on the equitable theory of unjust enrichment. This is not
what is the underlying core cause of action? Is it a contract in fact or a contract in law?
It is neither, Your Honor. I would suggest to you it is an equitable proceeding where we asserted a lien to begin with, and in Heinberg 1, as it's been referred to, that lien was found to be unenforceable for legal reasons. We then have an equitable claim that says, totally apart from any contract, we now look at the equities of this case. We have the equitable claim of unjust enrichment, which has a legal remedy to it, i.e. legal damages to it. And those two things are not inconsistent in the law. And in fact, we find them in Levine. And I think this Aery-Williams case is one that is...
With regard to your claim for damages, aren't you limited to the four corners of your complaint regarding your demand for relief?
Yes, sir, I think we are.
Demand for relief. Did you request relief based on the increased value of the lease?
The specific...
Damages based on the contract.
Your Honor, we pled the benefit of the improvements, I think was the word, and I didn't bring the complaint with me, but...
Well, looking at paragraph 14 of your amended complaint, it says defendant Fourth and Heidelberg LLC will be unjustly enriched if not required to pay the remaining balance of the reasonable value of the work provided to the subject property by plaintiff.
Yes, sir. And I think that you'll find, and I apologize for not having it with me, Your Honor, but I think you'll also find in the complaint that there is a claim for the benefit of the improvements that were made. There is no question that what was litigated in this complaint and this issue of limitation now to some language in the complaint is one that was not an issue at the trial court, as I recall. That we litigated that, and in fact, I take that back because Judge Shackelford made the finding or declined to make a finding on that issue because she had ruled that we were only entitled to what was on the face of the bill, so to speak.
In your amended complaint, you requested damages based on the contract price. Did you at any time move to amend the complaint?
No, sir. The complaint that you have there is the complaint. That is the complaint. Yes, sir. And again, I would respectfully urge to the court that what we've claimed is the benefit here, and what happened in that case was, as Your Honor is aware, that the Heinberg 1, so to speak, the legal claim was found against us on the statutory requirements. That then caused us to proceed on the unjust enrichment claim. And
Counsel, let me look at Levine for a minute, because Levine is sort of the opposite of this case. The parties in Levine were trying to have the court award damages based on the cost of the improvements, because the cost of the improvements were more than the increase in value of the property. Mm-hmm. So they were understandably wanting the higher number. This is a flip situation.
Yes.
I don't read Levine as necessarily saying that the only measure of damages is the enhancement of value of the property. It is certainly a measure that a trial court could use.
Well, if, Your Honor, under Head Note 1, which is on page, it's 713, it looks like it's only a one-page opinion, but here's what the court says. Although we agree with the owner that the damages for unjust enrichment in this case would have to be based on enhancement to the property from the standpoint of the owner, we do not agree that this requires reversal. But the court specifically says for unjust enrichment in this case, damages would have to be based on enhancement to the property. It doesn't say it may be based on enhancement and it may be based on something else. It says it must be based on enhancement. That is consistent with the Aerie case that's cited in the Levine case. And the Supreme Court in the Aerie case reversed in a similar situation where the trial court had only reimbursed for improvements. And the Supreme Court held that under those circumstances where this prospective owner had made improvements and was now seeking compensation, the Supreme Court said that under those circumstances, compensation was to be measured by the amount by which the improvements enhanced the value of the property, not by the value of the improvements, the amount of the enhancement. So I would respectfully suggest that that's what this case stands for.
Where is the equity in having requiring the owner to pay substantially more than the owner would have paid had it contracted to have these improvements made, and to have your client have a windfall for an amount substantially in excess of what it would have received had it been paid?
In every unjust enrichment case that I've seen, Your Honor, there's always someone that's going to have the windfall. That's by definition. In this case, because Montgomery Ward took bankruptcy, someone was going to get the windfall. There were improvements that were made. Those improvements substantially enhanced the value of the property. Judge Shackelford made a factual finding that is subject to the competent and substantial evidence review as opposed to a de novo review, that there was unjust enrichment. And what did she have in front of her? She had an owner that had an opportunity to pay for this. We specifically requested that we be allowed to come in as soon as they took bankruptcy, before anybody had occupied this property, that we could come in and take the air handlers off the roof and some of the equipment that were six-figure kinds of things in order to recover this difference it was owed. 14th and Heinberg refused. They refused to let us on the property. We then requested that they pay for it. They refused. They knew we had a lien. They went and purchased the termination of the lease from the bankruptcy. And so when you start balancing the equities, which is what Judge Shackelford did, Judge Shackelford said, someone is going to be enriched here. Is it going to be the owner of the property who refused to let us come in and get the equipment? And that evidence is uncontroverted. They admitted that. There's no question about it. Is it going to be that person, or is it going to be the person that did the work, that tried to get paid, that tried to get their equipment back, that asserted their lien, that did not get notice of the bankruptcy proceeding? Who is it that's going to get the unjust enrichment? Because someone is going to be unjustly enriched. There's no question about that. It's just a question of who is going to be the object of that enrichment. And I agree with Your Honor that these unjust enrichment cases are difficult cases for that very reason. Someone is going to be unjustly enriched. In this case, Judge Shackelford made a factual finding that the unjust enrichment would be in favor of Heinberg. That is, they were being unjustly enriched. She could have made, balancing the evidence that she had, a different finding. She could have made a finding that there was not unjust enrichment and that the payment for just the amount of the improvements was appropriate, but she did not make that finding. And so,
Counsel, at the time you your clients constructed improvements to the property in question, you did not have any ownership or possessory interest in the property. Is that correct?
That is correct. At the time, they did not.
It makes no difference in terms of your measure of damages, your client not having any possessory or ownership interest in the property at the time the improvements were made. I
think that is correct, Your Honor, in light of the bankruptcy that occurred in this case and the fact that someone, either Heinberg or Tar and Cronley, because Montgomery Ward went away, someone was going to have the possessory interest in it. It was going to be one of these two entities. There was no other choice. So analytically, in this case, I think it makes no difference.
Counsel, you're under a minute on that.
Thank you, Your Honor.
May it please the Court. Your Honor, begin, I'd like to invite the court to consider with respect to Mr. Daniels' statement about to the extent that this would factor into the court's determination, the issue of the discussion regarding the removal of equipment. The trial court's finding of fact is on page 3 of the final judgment that says, Mr. Tahar testified he inquired about removing the air handlers. He did not recall with whom he spoke, but did recall the person with whom he spoke was concerned about a potential hole in the roof, making unlikely it was a representative of Montgomery Ward, and more likely it was representative of the defendant. To the extent that Mr. Daniel represented that fact was admitted, it was in fact not admitted. This was the only statement was Mr. Tahar's recollection of a telephone conversation without a clear understanding of with whom he spoke. Your Honor, with respect to the prejudgment interest argument, I would invite the court to consider one of the cases that was raised by Mr. Daniel. It was actually in his brief, the Montage versus Athletech decision, and I felt that was very appropriate because the court in that case made a determination that the wrongful act, in that case the selling of a product with that incorporated the trade secrets of the plaintiff in that case, occurred at a particular date, and the court found that was the date that the damages accrued, but the court also determined that a later date, about a year or so later, was the date that unjust enrichment would begin to run, because that was the date on which...
Counsel, didn't appellant suggest to the trial court that the June 30, 2001 date would be an appropriate date for calculation of prejudgment interest?
No, Your Honor. I believe that was a discussion. If the court's referring to my discussion with Mr. Tahar, simply that was a question about whether he was aware that prejudgment interest is a potential remedy. Also, it was a question also to point out to the court that what Mr. Tahar and what the appellees in that case were trying to do was actually proceed under the penalty theory rather than the loss theory of unjust enrichment.
Counsel, in abundance of caution, just to paraphrase Judge Vendorf's question, did counsel suggest to the trial court that it could award prejudgment interest from the time the lease was terminated?
Your Honor, if I recall the testimony, I don't believe there's any suggestion of a particular date from which that would begin to run. There was a suggestion, if I recall, that prejudgment interest would be available to the court from a date in which damages were determined to be liquidated or to accrue. Right. It's simply as a matter of addressing the sense on the part of the plaintiffs below that they should be entitled to a remedy for having what they felt was their money wrongfully held.
Counsel, would you address the cross appeal, please?
Say again, Your Honor?
Would you address the cross appeal, please? You've got about a little under 2 minutes remaining in your time.
Your Honor, with respect to the Levine case, I believe the questions from the court were right along the lines that I would make. That with respect to the Levine case, first of all, the court approved damages based on the cost of the improvements, and also that there is certainly a qualitative difference between someone who comes in, contracts, pays for improvements with the expectation of taking full advantage of those through, in the Levine case, as a tenant taking advantage of those improvements, and with Montgomery Ward in the same way. But a general contractor, the expectation that a general contractor has is that the most that they will have is that they will be paid. And, Your Honor, with respect to the arguments that were raised regarding equity, I would invite the court to consider that unjust enrichment is actually a action at law as opposed to an action on the equitable side of the court, but equity does factor in, and that it would seem to be extremely inequitable for a claim based on 14% of the contract balance would generate an entitlement to the entire amount of some improvement in the value of the property. And I see my time has just about expired, so I'll rest on my briefs. Thank you, Your Honor.
Counsel, you have 51 seconds.
A couple of quick points. Number one, the expectation of a lessee in Levine is no different than the expectation of a contractor in this sense. If a lessee makes improvements and somehow gets evicted from that site, they're going to expect compensation for those improvements or the enhanced value of the property. What happens to a contractor is they expect payment for their improvements, but they always know, and we have a body of law, lien law and a common law, they always know they might end up the owner of that property if they don't get paid. So while the primary expectation is that they get paid, the reality is they might not, and they might end up the owner of the property. That is why I say there's no analytical distinction between Levine and this Airy case on the issue of...
Counsel, assuming Levine does authorize compensation for the enhanced value of the property,
Yes, sir.
must that claim be made for damages in your complaint?
Yes, sir. I think we have to have a complaint that asserts that, and I think we do. I think that's, my time's up. Thank you, Your Honor.
We will take a recess to reconfigure the panel in your